Hello, dear friends, my lovely audiences. You ladies and gentlemen, welcome to the East-West Show. However, today we are opening a new area talking about we the people. We all know that under the Constitution, we the people deserve the best. How to get the best we deserve? That's the question. That's why we have a system. At least we have a so far healthy system, legal system, to protect us. Today, in the first of the series, We the People, I have my friend who is playing my co-host now, Mr. Thomas Johnston, a trial lawyer. Welcome to the show, please.
Thank you, Jack. It's great to be here, and I'm happy to be doing this with you.
Though he's smiling, he bites. He bites a lot in court. That's why he keeps his record of winning straight up, right? So I'm not degrading you. Biting is a good thing, right?
Well, I think it is. Sometimes justice requires that, Jack.
Oh,
so
very good, very good, very good. And next to him is our guest today, Mr. Sean Nifsey. Mr. Sean Nifsey is a trial attorney. He specialized in patent litigation, including copyrights or electronic stuff like that, or devices. And later on, I'll give each of them a moment of self-introduction. Sean, welcome to the show.
Thank you, Jack. Thank you.
Very good, very good. I know both of you are good attorneys. That's why I get here for understanding, a common understanding. Here we take the best, nothing, only the best. So you guys are obviously the best to my eye. So to both of you, you're welcome. To my audiences, I would like to use this show as a window to get to more knowledge to our audiences, through which they will probably take it as a piece of education. Now you're in the country, you're in the system, better to learn. All right? To kids like my son, he was born here, he went to school, he's all the way to college now. He might not necessarily know the system himself, right? So that's a start, right? How about Sean? Let's start with Thomas. And now that you're my co-host, you got a job to do.
Well, so thank you, Jack. Well, let's talk about what we the people means. And that is the Constitution of the United States, what gives us our rights, what makes us who we are as a country. And we are a country of laws and protections. So what the Constitution does is it divides power, so no one has too much of it. We know about the president, that's the executive power. There's the Congress, who's supposed to write the laws. And then there's the court system, that is supposed to be where the laws are enforced. So the president and people that work for him, if they want to enforce a law that the Congress writes, it has to go through the courts.
Okay.
The courts are not political. They are designed so people can go and get justice. And what is justice? Justice is a fair outcome for any type of problem. The Constitution, we hear about it. It gives us our rights, the Bill of Rights. And the 7th Amendment gives people the right to a jury trial for different types of
Everybody deserves a fair trial.
Everybody. And so what's great about that is we know about criminal cases where someone's committed a crime and they have to go to court. Well, in our system, we say no one goes to prison unless they go to a jury who says that person's guilty beyond a reasonable doubt. But courts are open to people not just for crimes. But what if a person's been harmed somehow, or his business has been harmed somehow? Those laws protect that person in business too. And sometimes people get harmed by stealing ideas, if a person has an idea. And that's where Sean Nifsey, a lawyer like Sean, can help someone who has an idea that's been taken by somebody else.
Very good.
And
Very good.
That's what brings us to
We
today.
all understand that we have the the top 10 of our Bill of Rights, and we're talking about number 1, which is quite often used, number 2, quite often used, and now we're talking about number 7, which is that everybody deserves a fair trial, and you're not going to prison until you're going through that, when it's confirmed, convicted, or so on and so forth. And beside of that, and in the civil area, though, nobody's going to be cheated or, well, taken advantage of, because everybody deserves it. That's Sean's area of specialties. Sean, your little introduction, please, because he is not new. Everybody knows him, right? And you're new here, so some little bit about yourself. You can tell us anything. Your saving account, your girlfriend's name, how many you have, their telephone number, stuff like that. Just feel free.
Let me act as his lawyer
you,
for a
Jack.
second. I know Mrs. Neefsey, so there are no girlfriends.
Come on. Let him do the explanation.
You got it, Jack.
All right. I'm just to make him feel relaxed.
Of course.
Go ahead,
Thank
please.
you. Thank you, Jack. I've been practicing, I'm an intellectual property trial lawyer, and I've been practicing in Los Angeles for over 20 years.
Wow.
And my specialty is protecting my clients' ideas and also protecting clients who have been wrongfully accused of taking somebody else's idea. It's great that we're here today talking about the U.S. Constitution, because the patent system is in the U.S. Constitution, and the founding fathers of the nation over 200 years ago knew that patents were so important that they put patent protection in the Constitution itself. So we counsel clients at my firm. And we enforce their rights when they've been copied by others.
All right. Okay.
Let me stop you
Yeah,
for a
sure,
second,
yeah.
Sean, and let me go backwards, because I didn't know that. So when the authors of the Constitution gave people the First Amendment, their right to free speech or freedom of the press, or the Fourth Amendment right to have no illegal searches and seizures, or the Second Amendment right to bear arms, at the same time they were thinking about patents?
At the same time, in Article 2, which creates the Congress, there's a provision where the founding fathers instructed the Congress to make laws to protect patents. And that's extremely important, because a patent is the only way to protect someone's idea.
I'm
copying.
very happy you mentioned that and you pinpoint that. I know that it's under protection, but I never know it is written there, right? That's one of the provision, right?
Yes.
It's written there, the patent rights needs to be protected through Congress, right? That's a good piece of knowledge to know. All right, all right. And now that you're my show, my co-host, you really got to co-ed, right?
Okay.
Yeah, you really got to co-ed. So I want to ask you a question for you both. Of course, you guys know each other of your own area. For the audiences, they need to know the difference between you two in the two areas. I know you're a trial lawyer, and so if I want to find a definition equivalent to your trial lawyers, what would I call him?
Sean is a trial lawyer in that Sean can try any case, and I know that, but he has an additional specialty with patent litigation where he can try.
I see.
So let me just talk to you about it. Let's put it into medicine. You can go to a doctor. Well, there's a lot of types of doctors. Some are surgeons. Some are brain surgeons. Sean's the equivalent of a doctor who's also a surgeon who also happens to be a brain surgeon. So he's doing it. He can do everything. He can be a regular practitioner. He can be a regular trial lawyer.
He is a trial lawyer as a whole. He specializes in the area of patent protection.
Yes.
One of them. right?
And yes, and he can try that in a courtroom. And what makes Sean special, and he's not going to tell you this, so I'm going to tell you this.
What is the difference between a lawyer and a trial lawyer?
Well, let me handle that too. The
Yeah.
trial lawyer is in a courtroom, and a courtroom during a trial. And a trial is a competition. There's one side that's trying to get one outcome,
Yeah.
and another lawyer's opposed to it, and you fight it out. And a jury or a judge decides who wins. So it's a special area because there's a winner and there's a loser, and the lawyer can really make a difference. And that's what Sean does. And what's unique about Sean is he can handle this type of very complicated patent litigation, but do it in a human way where a jury can appreciate that. And Sean, that's very rare because some people that do patent litigation, they get so caught up in the invention that they can't tell the story. Sean, he tells the story.
I see. All right, very good, very good.
If I
Sean,
could, we mentioned, Jackie mentioned the Seventh Amendment and why that's important here. And the Seventh Amendment gives everybody the right to a jury trial in this country. So any sort of dispute is resolved by a jury. So if someone copies your patent, that's resolved by a jury. If someone violates a contract that you entered into, that's resolved by a jury. If you're in an automobile accident and someone wrongfully causes you personal injury, that's caused by a jury, or that's resolved by a jury. So all disputes are resolved by a jury, and I specialize in resolving patent disputes before a jury.
Copyright.
Copyright, patent,
Intellectual right.
intellectual property.
Intellectual property right.
Yes.
Something like that, right?
Yeah.
That is a subject, my dear audience, is that I believe that we all should learn more about, because especially you come from, here's the country of diversity. Everybody coming from all kinds of countries or areas or regions anywhere, bringing different kind of legal concept. For example, something, well, might be taken so common in China, here is illegal. For example, we can spank on the butt of our kids, right? Here you can't. So back then there is can't. All right. So now with the patent protection, though, lots of people do not realize they have the right. And whenever a patent is mentioned, they tend to think about huge, like a rocket science patent, stuff like that. They never know something like a ball pen might apply for a patent too. For that, I believe, when take a short moment now, come back, we need to start education with your trial case to typically tell people, regardless of big or small, a patent right is a patent right. Right, needs to be protected. You agree with me?
I do.
All right, very good. Yes, I do. Okay, let's take a moment out. When we come back, we'll continue. Today with me, two trial lawyers, Mr. Thomas Johnston and also Sean Nifsey. So, and we take a moment out. When we come back, we'll continue. Please bear with us. Hello, dear friends, my lovely audiences, ladies and gentlemen, welcome back to the show. As a matter of fact, we're opening a new area, a whole new area called We the People. This is number one of We the People series. With me in the opening of the new series are two wonderful friends who I believe we rely upon whenever our rights are being taken, right? And to my right, Mr. Thomas Johnston, a trial lawyer, a winning record straight up trial lawyer, and to the right hand side of him, another trial lawyer specialized in patent protection, Mr. Sean Nifsey. He is also a good record lawyer for more than 20 years. And I did check with him. He has no girlfriend, and well, we'll close up on that, right? So, right. So, okay. The case adjourned, like that. Okay, right. Okay. Now, welcome back to both. Welcome back to the show. And Mr. Johnston today has a job to do. He's acting as my co-host because in law stuff, in legal stuff, there is a totally brand new area to me. I have to have him ask questions when it is necessary to be asked. I do not even know, right? So I'm learning. They take me as one of your students whatsoever. Okay, I'm not paying you. Anyway, so to both, welcome back. Now, okay, now we are happy that we can be protected. Our patent, be good, big or small, be it big, be it small, are protected equally. But those definitions we need really to know, right? What is the copyright? What is the patent right? What is the invention right or something? Or somebody say idea. What is idea? Something like that. Do you think so? We, the people, need to be taught in a way, well, in a way that we deserve, right? So you, maybe Sean, or you?
Well, I think it's great, Jack. Let's start, Sean, if we can, at the very beginning.
Yeah.
And some of the terms I think we use for each other, and maybe that's not the best way to do it. Could you start with what patent means and then go through some of the popular terms and tell us what that means?
Exactly.
Sure. So the broad area is called intellectual property, and it's called intellectual property because it's a property right, just like owning a piece of land. But it's intellectual property. It's an idea, and the boundaries of that idea are protected in the intellectual property right, just like the boundaries of real property, a piece of land, are protected by the boundary of the land. So a patent protects ideas or inventions. Copyrights protect works of art, such as this program is protected by copyright. A drawing, a book, a song, that's all copyright protection. And then the third major area of intellectual property is called trademark, and that generally protects people's brands, such as the Coca-Cola brand.
Okay.
So today we're focused on patents, which protects ideas, and that's the only way under the law to protect an idea. And without a patent, my clients would be at risk of anybody just copying whatever the idea was.
Okay, I see.
So,
for that, I may just insert one more question or two more questions. So, to each of the patent whatsoever, right? It goes with the equivalent of, area. To what kind of area? Is it international? Everybody should be restricted from using it, and also for a period of time. Right, such as I wrote a book, right, and how long shall I keep the right, right, something like that.
Yeah. Well, let me help you with that a little bit, Jack, if I may.
Please.
There might be different protections for the different. There might be different rules for the different protections. So, for example, if it's a book that you wrote or a piece of music that you wrote, maybe it has different rules than of an invention. So maybe you could explain that to us a little bit.
Yes, that's a great question, Jack. The patents are only protected for 20 years. Copyrights are protected for a much longer period of time.
I see.
And the idea behind giving patent protection a limited amount of time is the patent reflects a bargain between the inventor and the public.
I see.
And that public is, in exchange for being given 20 years where the inventor is the only person in the United States that's allowed to make, use, or sell that invention. At the end of the 20 years, because the inventor has been given a legal monopoly on his or her invention, it goes over to the public, where then the public has the benefit of using that invention.
I see.
So for example, when Thomas Edison invented the incandescent light bulb, he had the ability to sell that exclusively for 20 years, but the framers of the Constitution recognized we need to keep moving forward, and so after 20 years, anybody's allowed to make a light bulb,
All right.
that type of light bulb. If you make a better, newer light bulb,
And
then you
have
get a
another
new
patent, right?
patent
Okay,
on
very
that
good.
on that light bulb.
That sounds very reasonable. And you know, Thomas, is it possible? I mean, is it better we ask Sean to explain what his recent case, the case itself, by dissecting the example case, though, probably my audience will learn more.
Yes.
You think so?
I think that's a great idea. Why don't we do it this way? Sean, why don't you assume the role of your client, the inventor, and tell us what he came up with and how he did it.
Yeah.
I will.
From the case, like
Great,
yourself. Yeah,
great.
yeah.
Could I answer one of your questions first?
Yeah.
The patent is only protected in the United States. To answer your question, if you want protection in another country, you have to obtain a patent from that country. So the government of Canada issues their own patents. The government of China issues their own patents. Every country issues their own patents.
If I want to be internationally protected, I want to apply each and every single country.
Yes, that you think you might sell your product into.
I see. Very
and it
good.
gets expensive because you need a lawyer to apply for the patent.
Okay.
So, but yes.
And what is the case that you recently represented? I learned from him. Thomas told me that you had a very excellent case that you just dealt recently that protects a Chinese American inventor.
Yes. My client was a Chinese American. He came
Let me
to
stop you for a second. It was the highest verdict in 2017 for a Chinese American inventor.
Oh, yeah. Even better. Even better.
I wanted to put that
Even
in there.
better.
So I'm sorry, Sean, but I wanted that to be in.
Even better. Okay, very good.
Yes.
Yeah.
Very honest man that came from China in the 1980s, and he developed his own business. And part of his business was developing new products, and he specialized in making blinds, window coverings. And every little aspect of the blinds that he sold, he would create new designs for. He would identify problems from the existing products on the market and invent his own way of solving those problems. And his invention here was this mechanical device that goes inside what's called the head rail of the blind, and it made the operation of the blind much better over what had been on the market before.
Oh, I saw you walking with a blind.
Yes.
Was that
yes.
to indicate how it works or display it?
It's great. Let's bring up the blind, okay?
Okay.
And let's bring it up. But I want to set the scene a little bit, Sean, where I want to get a feel for where your client did these things. Was he in a big office building, or was he in some laboratory coming up with ideas?
My client started his company out of his garage, and so he would start drawing. He's a very talented designer, product designer.
I see.
And he eventually grew the company because he made his own products and didn't copy anybody else's. And now he has a facility, and in that facility, he walks around with a pen and paper, constantly thinking of ways to make his products better. So he's in his warehouse. He's one of the drawings we had for this product was him at his kitchen table at 10:30 at night, thinking about how to make this better, constantly drawing, putting a lot of time and effort into coming up with this product, which is the whole reason behind the patent system. Because if he came out with this product and just sold it and didn't have a patent protection, then all that time and effort could have just been copied by anybody without any protection in the legal system.
Exactly,
And that's why patents are so important.
Yeah.
But that's so powerful, though. I mean, I imagine this man who had the courage to come to this new country, and he has a brilliant mind, and he's at his kitchen where he's doing things where he has free time when his kids are asleep or it's after dinner, and he has a choice with his great mind. He can copy somebody else's invention, or he can be careful not to do that and come up with his own.
Oh yeah, of course.
And he
of
comes
course.
up with his own.
That's another story.
And that's wonderful.
Yeah, sure.
So Show us, Sean.
Oh, yeah, Thomas has it.
What is this? And talk to us about it.
Yeah, Jack, to your point, a patent protects any new idea, not just Elon Musk's new rocket.
I see.
So
Yeah, sure,
any
sure,
new idea, that people come up with, they should consider obtaining patent protection on. So this is a blind. It's a kind of a typical Venetian blind.
That's the type that we use at home, right?
Yes, yes. And this device is called a cord tilter, and it sits. You never see it, but it sits inside the headrail of the blind.
I see.
And when it's in there, the cord comes out, and this device is what's used to open and close the blind, as opposed to this cord.
You no longer have to touch the leaves,
Yes.
right? Just by pulling those strings,
Yes.
you'll get what you want.
Yes. Yes.
I see.
And there was lots of problems before where these would get stuck. It's inside the top. It's up in your window. No one knows how to fix it, and then your blind is useless. So he spent hours and hours. It took him over a year to develop this idea. He came up with 2 or 3 ways of doing it that didn't work that he tried to sell.
I see.
And eventually he came up with this, which is the best one on the market, and it solved all the problems that were on the market before.
And then what happened that it was stolen?
Yes.
All right, very good. My dear friends, my lovely audiences, as how the blind works, that's a different story. I want to hold the main point. Of course, I believe Thomas agrees with me that the patent needs to be protected. We want to find out how the idea being protected and turn into the highest winning case, a patent protection case, as long as the Chinese Americans are concerned. Am I right?
Yes. So Sean had the largest jury verdict in this area for a Chinese American inventor that I certainly know of, and I look at these things every single week for all of 2017, and that's a very big deal, Jack.
Very good. That's a big victory. My dear friends, my lovely audiences, we the people at this new series, we just opened up. Number 1, we're talking about patent protection. Joining me is a patent lawyer, trial lawyer, of course, Mr. Sean Nifsi, and also my co-host. I have a co-host to help me because in case I'm asking any wrong questions, we're talking about the legal system anyway, whole thing, right? Thomas Johnston, he is a trial lawyer himself. And he, of course, handles a broader sense. Anyway, we take a short moment now. When we come back, please, Sean, we want to find out at what point he was so bothered, right? At what point he reached to you, how you started weighing the subject or the case, and step by step. How about that?
That sounds,
right?
Sounds good.
So, hello, dear friends, my lovely audiences, my dear fellow Angelinos, Californians, or my fellow Americans. Welcome back to the show. As a matter of fact, today is the opening of the new series, We the People. We want to bring education to our friends. We want to imbue our life with positive information rather than negative information, such as me too. No, I don't want to talk about that. Those are so boring. Okay, talking about in this country, beautiful country, under democracy, you have the right to protect yourself, and including the fact that your invention, your patent, your copyright, your intellectual property are all protected. To get to it, my 2 excellent friends are here with me. I have Sean Nifsi. He is a trial attorney specialized in intellectual property protection, and also my friend Thomas Johnston, a winning trial lawyer, straight up record, biting so much. when you eat chocolate, anyway.
Yeah.
Yeah, helping me, okay, come on. So let's get to the point, shall we?
But yeah, Jack, but we should say, you know, that Me Too movement, I think is very important. And I don't want to sidetrack your show, but, you know.
Well, another day, come on.
Another day.
Another day,
Okay,
yeah, another
you
day.
got it.
And
Okay.
I do have a tons of comment to make.
Well, then,
I do.
Let's
right?
let's have.
Sure, very good. And back to Sean though. Oh, Thomas, you think that the client, his client, did the right thing utmost was that he got himself patented.
Yes.
Am I right?
Yes, I think we should start with that briefly,
Yeah,
Sean,
please.
and then talk about your case.
Yeah, what's very important is after you come up with your idea, the patent right doesn't automatically attach. It's different from other intellectual property. Copyright automatically attaches as soon as you finish your song or you write your book. But a patent you have to apply for and obtain a patent from the government, and if that's not done within a year of the date you sell or display your product for the first time, then you're ineligible to obtain a patent. So if someone has an idea out there that they think is new, it's important that they look into getting patent protection right away, otherwise they'll lose the ability to obtain it.
May I insert myself a little story? I could be a millionaire or a billionaire, who knows, right? I came here the year of 84, right? About a year and a half, when I was in China, I came with an idea about the billboard. The billboard, that back then you have no LED or LCD whatsoever, right? All you have is one face board, like thing like that. I said, okay, if I would do this, say, like what they do, see, right? Triangle it, right? And then you put many of them. Boom, boom. You could triple the surface of the billboard, right? That was a year ago, a year and a half before I came to the United States, right? So when I landed in LAX, oh, it is right there.
Really?
I thought about it, swear to God, I thought about it a year and a half ago. And they said, underneath, brand new technology or something like that.
Oh, wow.
That's what happened to me. So it is rather important that you have your idea patented.
Yes,
Am
to
I right?
apply for the patent within a year of the date you first sell it or display it. And your example is a great one, Jack, because, for example, in this case, the defendant, and the defendant in a lawsuit is the person that is being sued, claimed that our patent was invalid. And one of the reasons a defendant has the right to claim or assert invalidity is that something was invented before. So in your example, if you had obtained a patent on your idea, the defendant would have, let's say you obtained a Chinese patent, I'm sure the rules are similar. The defendant would have searched the world to see if it had been done before, and if they discovered that your idea had been done before, then your patent's invalid.
They would have approached me, buy it, right? Something like that.
Well,
Then,
your patent would be invalid.
All right.
So in order to be patented, it has to be new, and that means in the four corners of the world, it can't have been invented before.
But anyway, he did the right thing. So at what point he thought he needed help, he came to you, and at what point you decided that you have a case?
Thank you. So he obtained his patent, and then he discovered from seeing competitors' products on the market that his idea had been copied. And the first thing he did was to simply ask the other side to stop copying his idea. And he did that himself first, and they refused to stop. And then eventually he approached me and asked me to take a look at the issue. And so I studied his product, studied his patent, satisfied myself that it was a valid patent, and it was a new and novel invention. And I realized this honest man had come up with a great idea. And so then I approached the other, before even filing a lawsuit, All we did was ask
You
them,
offer them a chance of corrections.
yes, just to please stop using my client's idea. 3 times we asked over the course of over 6 months,
Okay.
and they refused to stop. So that's when we took the very significant step of filing a lawsuit, which is the beginning of the process to eventually go before the jury in a trial, and then the jury decides whether they should stop or not.
How long did it take from filing to verdict?
It took about a year and a half from filing to verdict.
Not extremely long.
No, other cases could take up to several years.
Yeah.
So that Sean
Not
got that to
extremely
verdict
long,
fast.
Yeah. Oh, very fast, right? So, and lots of people would be interested in the fighting itself. The fighting is very encouraging to people like us outside of the parameter, because we want to watch like a show. However, by watching, we learn, right? So, what is the argument about? Of course, I could almost tell, it is not a plain sailing all the way, or landslide that Sean wins, right?
Yes.
And it goes back and forth, back and forth. What is the argument side?
The argument is, in a patent case, is generally 2 things. Usually when someone copies another's product, they don't copy it exactly. They try and make it a little bit different to make it appear that they came up with the idea on their own.
Oh, I see.
So the other side's cord tilter did look a little bit different than ours. And so their first argument was, we didn't copy your product. And so that required us to show how they had access to our product, why it was more likely than not that they didn't develop this idea on their own. Instead, they copied my client's product. And we proved that with things like, my client had sold millions of these, and so they were readily available on the market. That's why you need a patent protection, because as soon as it's on the market, anyone can copy it without a patent. They were in the same industry, they were competitors. We didn't have sort of what they call a smoking gun, where he was sort of caught copying. That's what the lawyer's job is to present the evidence and to allow the jury to conclude that we believe that the defendant copied my client's product.
Yeah. Earlier, I believe that you showed me some pictures about the 2 devices identical to each other, right?
Yes.
That's the one?
Do you want to show this to the camera?
Yeah.
So this is an actual trial exhibit at trial, and one of the most important aspects of this, it seems simple, but it took my client over a year to come to this idea, was to use this simple little slot is what's called the pulley. And so we were able to point out that aspect of this was virtually identical. But you can see they tried to do other things to make it different.
Yeah, look
this
different.
top is different, that's different. But what the lawyer's job is, the trial lawyer, is to convince the jury that
Lots of needle points, right?
Yes.
Let me do this,
Yes.
Jack, if I can.
Yeah, sure.
Now, had this client of yours, this inventor, who had drawn at 10:30 at night in his kitchen table, had he ever been to court before?
He had never been to court before. His
First time.
First day in a courtroom was about 5 days before our trial started.
Okay, I want to stop that for a second right there. Let me set the scene. So you have this man of courage who comes to a new country. He has brilliance. He comes up with a new idea. He does it the right way, protects it. And now he has to go to court, and it's a federal court, right?
Yes,
So,
yes.
So tell us what it looks like. What would it look like for him if he's on the sidewalk looking at this place?
Yeah, it's really a wonderful story, because here you have this wonderful Chinese American that came, and he put all of his faith into our legal system, and the legal system protected his right.
Which did protect him, yes.
Yes, and so this is Thomas is right. We're in what's called federal court. So this is a federal judge that's appointed by the President of the United States.
I see.
And
all the way up.
All the way up, yeah.
All the way up.
Yes.
One of the nines. One of the nine.
Not
right?
one of the nine. Every federal, that's the Supreme Court. So that's the highest court. And then you have your intermediary court of
under
appeals.
one of the nines.
And then, then you have trial judges all around the country, and they're all appointed by the president. So very brilliant, hardworking judge. A very serious judge.
Article 3 now.
Article 3.
So Constitution, we talked about Article 2, Sean did. Now we're in Article 3, the judges.
There's three parts of the Constitution. Article 1 creates the presidency, 2 creates the Congress, 3 creates the judiciary.
The judicial.
These are called Article 3
judiciary
judges.
system,
Okay,
yeah.
well, let's go back to your client. Now, this person has to go to court for the first time in his life, and it's you and your client. Tell us what it was like when you're sitting there after your trial, and you two are sitting at a desk, and the jury comes back with its decision. Tell us.
So we're
The moment.
We're sitting in the courtroom. The judge is up on, just like on TV, up at a high chair. The jury is sitting to the right, the other lawyers to the left. There's law clerks, and it's very formal. And the jury walks in, and the judge asks the jury, "Have you reached a verdict?"
Have you reached a verdict? We often hear that, yeah.
Yes, we have. And the jury writes it on a piece of paper, hands it to the clerk. The clerk hands it to the judge. The judge reads it to make sure it's proper, and then hands it to the clerk. And then the judge asks the clerk, who in this case was a woman sitting in front of the judge, to read it. So it's a lot of drama and stress after a year and a half. And so
Let's see it. I'll be your client, you be you, and then read it. Okay.
Yeah, what happened?
It was my client. We were sitting together through the whole trial. He put his hand on my leg, and he turned to me and he said, "We've told the truth. That's all we could do, and I'm comfortable with whatever decision the jury decides. It's a true story.
I'll be him because I'm comfortable to whatever the jury does.
Yeah, because we told the truth. He put. He's a very religious man. He's closed his eyes, put his head down.
I see.
And then the 3 questions were asked. Two questions were asked. Did the defendant infringe, that's the legal term for copy, did the defendant copy my client's product?
The verdict says yes.
And the clerk reads yes. And then the second question is, how much has my client been damaged? Which is the amount of money that the jury is allowed to award. And the jury awarded over $1 million because which was the total amount that we had asked for. Didn't lower at all. And he just breathed an incredible sigh of relief. It wasn't so much about the money at all, really, for him. It was about protecting his right to sell his products that he invented, so that others just stopped copying him. That's
What
all
a moment.
Isn't
What
that
a moment,
great?
right?
Yeah.
And that deserves a script. Somebody writes a script about it. Yeah, it is very educational. All right, my dear friends, let's wrap it up for a segment, and we'll come back to find out the excitement in all the details. I mean, all details in the excitement. There are education to find out, and I found it very important to do so. Stay with us, please. Hello, folks. Welcome back to the show. We're talking about We the People, a brand new category that we opened as a series. Today we're doing the first one, We the People, number 1, patent rights protection. With me in the first one, my co-host Thomas Johnston, a wonderful trial attorney, winning trial attorney for many important cases, and my other friend, Mr. Sean Nifsi, that's a silent K there, right?
Yes.
Mr. Sean Nifsi, he is a trial lawyer too, specialized in intellectual property protection, right?
Yes.
And talking about his case. Well, as a matter of fact, he's won lots of cases. We're just taking that case to dissect it, see if there's anything we can learn from to understand the system, right? We came to a point at the end of last segment, at the very moment when the verdict was announced, what a jubilant atmosphere that was at the courtroom, right?
Yes.
So the award was $1.5 million or $3.5 million. I read papers says $3.5 million.
Yes. There was a third question that was asked of the jury, and that was the infringement, was the copying willful? Willful meaning intentional.
Okay, intentionally.
And the jury found that the copying was willful.
Was willfully.
So that was the end of the jury's involvement. In patent cases, unlike in other cases, such as personal injury cases, the judge has the ability to increase the amount of damages based on the intentional nature of the violation.
I see. Oh.
Yes. In personal injuries cases, it's called punitive damages. In patent cases, they're called enhanced damages, but they're both
enhancement damage.
Enhancement, yes. They're both designed to do the same thing, and that is to punish the infringer.
To
for
punish
intention.
the bad action.
Yes.
Yeah.
Yes.
Good. And how much did the judge punish?
So, under the Patent Act passed by Congress, the judge has the ability to triple the damages. Triple, it means multiply it by 3.
I see.
So this judge had the ability to take the $1 million and make it $3 million, and that's in fact what he did.
Wow.
He took the $1 million, he made it $3 million. He further awarded interest, which was another $166,000.
I see.
And attorney's fees, which was another $400,000. So the total judgment will be over $3.5 million.
$3.5 million.
Yes.
Oh, this
Yes,
Chinese American guy, well, wins a big time.
I think it's wonderful, Jack, and I think it's important that we just take a second and acknowledge his courage in coming forward.
Yeah, of course, yeah.
And the jury's courage in coming up with a verdict like that. And particularly my friend Sean, who took a case, then they have very good lawyers on the other side, and they wouldn't budge. No. All they said was no.
Okay.
And they went together into a courtroom and put together a case, and they convinced that jury and the judge to do the right thing. And it changed. It changes everything. And I just want to talk to Sean about that for a minute. What did that verdict change for your client?
Well, it changed his role in the market so that, because the other thing the judge did was issue what's called an injunction, and that is an order from the court ordering the defendant to stop copying.
Yeah, take back his product already sold.
Yes, yes, and at that point, it becomes a criminal violation if the judge, if they continue to sell it.
Oh, there's a heavy punishment.
Yes. So before, competitors knew that he had to file a lawsuit, that he had to hire a lawyer, he had to go through this process. But now, because my client has, I believe, over 50 patents. He's invented a lot of different components. He marks his patents marks his products with the patent number. And so now it's given him the peace of mind that his competitors know, please do not copy my products. You're free to create your own products. You're free to come up with your own ideas. Just don't copy.
That's the lesson learned.
Yes.
That's the biggest lesson learned. To what extent do you think, or do we think, the jurors could be fair?
It's really a remarkable thing, the jury system. The reason for the jury system, and it's unique in this country, even in England, and our system derives from England, there's not a right to a jury trial in many civil cases, is because it required my client, it required me to go back to the community here in California, and there's a process where 8 people were picked to be fair, that they don't know anyone, they don't know any of the parties, and they're checked for that. And they are, the lawyers and the clients are required to go for people that they don't know to convince them to do the right thing. And
they have no knowledge about pattern, about the device itself, nothing.
They have no knowledge about any of the parties or any of the clients in the case, and that it's really a remarkable thing how juries get to the correct results.
Let me stay in this. And I want to talk about you personally, and it's Sean Neefsey, and I want to tell people how they can reach you if they have to. And it's Neefsey's with a K, and it's KNEAFSEY firm, neefseyfirm.com. And I know you wouldn't want me to do that, but I insist. But I want to ask one question.
Oh, no, also, my audience might need your help. So as my co-host, right?
We'll come back to that, because my job now is a co-host, okay? So we the people keep coming back.
We the people, keep you fair.
But I was touched by the story of the verdict and how that changed your client, and I imagine it changed the jurors that sat on that case. Did you, as the lawyer, even though you're a professional and you have the lawyer title, do you think that verdict changed you in any way?
I think it did. Because I learned, and one of the great things about being a trial lawyer is, in order to be a successful trial lawyer, you have to really come to learn and know your client. So because that's what you have to convey to the jury, the time at the kitchen table, the process of coming here, and the fear and developing it, all the hard work and that went into creating this business and these ideas. And so I learned so much from my wonderful client.
Everybody learns in the case, right? Everybody learns. And we are running out of time. I have one question left that I have to ask, right? I really have to. You're talking about similarity. You're talking about try to look different, right? As a matter of fact, the essential is there. Okay, this happens exactly more in the Chinese community, Chinese American community, because in Chinese every word has 4 tones. You go flat, go up, go this way, turning and going down. Bo 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 bo, like that kind of thing, right? And also, there are words with the same pronunciation, different words, different writing, right? So for that, if you have a business called ABC, and then I do in the Chinese way, I'm just trying to explain it, say ABC, well, I do it in a different way, SEE, something like that. Also ABC. And it sounds ABC to everybody, ABC. For that kind of thing in the gray area, is that a violation?
There's a lot to that question, Jack. So I would just, broadly, Sean, what do you think about that? I mean,
well, that's one of the hardest parts about patent cases. That is probably the hardest part about patent cases, because
I have a product and I name it ABC. ABC, 3 letters, right?
Yes.
And then you do yourself something, ABSEE.
Yes, because actually the patent is the patent test is not comparing my client's product to the others. The patent contains a written description of the invention, and it's that description that is compared to the product. So there's incredible hurdles involving language. There's enormous fights in this case and in every patent case over what ABC or SEE means, to use your example, and is that difference enough where they get around the patent? Because if they don't literally meet every requirement of the written description of the patent, then they don't infringe the patent. So
there are still hurdles, right? Do you think so? But to the common sense, we know that he's copying.
Yes.
Because ABC sells too fast.
Looks can be deceiving. So
can be deceiving.
right. So
Very good. Anyway, we're over time, my dear friend. And for the first of the We the People, I believe we did a fairly good job. And the credit goes to my host, Mr. Thomas Johnston. He's a trial lawyer himself, and a trial lawyer, Sean Neefsey.
Yes,
All right.
thank you.
I have time to omit the K. Okay. And I believe that later on we'll continue with all the different kinds of cases. We'll put up a series for you. Anytime you can come back and relook at it. Right. So thank you very much for watching. And to Sean, thank you very much. To Tom, thank you very much.
thank you, Jack.
All right, good.
Thank you.